Now I'm going to talk about a different matter that did not result in a lawsuit, but which resulted in changes to business practices by a fairly prominent company. This is an action that I'm very familiar with because we initiated it in 2012 while I was serving as Attorney General for the state of Washington. First, a little bit of background. The company involved is Embraer, the world's fourth largest aircraft manufacturer, domiciled in Brazil with commercial, military, and executive aircraft applications. Evidence was brought to the Attorney General's office in Washington that the company was engaged in significant and deliberate under-licensing of some of its software. In fact, there was evidence presented that while they had purchased 10 licenses for a particular program or suite of programs, they had installed those software packages 3,300 times against the purchase of 10 licenses. The loss to the Washington software vendor involved was estimated at $3.3 million, and we were also concerned about the unfair competitive advantage that not paying for software provided to Embraer vis-a-vis its aircraft manufacturing competitors like Boeing and Canada Air. There was an effort by the software vendor to obtain cooperation, and then a preliminary effort by our office to obtain Embraer's cooperation, and those efforts did not prove fruitful. Fortunately, the prior year, we had worked with the Washington State Legislature to adopt a statute on stolen or misappropriated information technology. It's codified at RCW 3.19.330.020. That's RCW 19.330.020. It states in relevant part that any person who manufactures an article or product while using stolen or misappropriated information technology is deemed to engage in an unfair act where such an article or product is sold or offered for sale in this state. So in California and Massachusetts, you have cases that have been brought under their statutes prohibiting unfair and deceptive acts and practices, or their UDAP laws. In Washington State, of course, we have the same type of UDAP statute, but in addition, we also now have RCW 19.330.020, which specifically calls out and prohibits the use of stolen or misappropriated information technology, deeming it an unfair act in each case. Now, when this information was brought to our office, we faced an initial challenge of just figuring out what we could do to enforce this law against a company where we had significant evidence that they were misappropriating information technology. Consider the limitations that we faced. First of all, there was the question of staff time. We were already quite busy in our antitrust section. Secondly, there was a little fact that this aircraft manufacturer is based in Brazil and we're based in Washington State. Third, we knew that if we needed to engage in extensive discovery, that a lot of the documents would be in Portuguese as opposed to English. Fourth, our budget could not bear a high cost or high risk because the antitrust budget in Washington State is funded on a revolving fund basis. So it's important to be able to recover costs and fees to replenish that fund when an action is taken. There's also a matter which is fairly unique to Washington State, where when the state attorney general brings an action and ends up not being successful, which fortunately rarely happens, the state of Washington can be held liable for attorney's fees. So we have to be particularly mindful that when we bring a case, it needs to be a very, very solid case to avoid or minimize that risk. Well, the easy answer, given all of those questions and all those hurdles, would have been to do nothing, to simply shrug and say, well, sorry, we'd like to help, but we don't have the resources, or the resource cost would be too high for us to help. Fortunately, we found another solution. The solution was to send a strongly worded letter to Embraer, citing the statute, citing the evidence that we had, and to put pressure on the company to do the right thing given that evidence. And to their credit, the company did take the right step. They did end up paying for the use of the unlicensed software, and that benefited the software vendor, Microsoft, as well as competing aircraft manufacturers in North America, including Boeing, Canada Air, and others. So this example is given today as part of this webinar because it shows that there are other avenues available to state AGs as enforcers of their UDAP statutes, short of bringing a lawsuit. And in this case, we felt that the effect of obtaining this settlement or this compliance showed that there is a sentinel effect, a deterrent effect from taking action when appropriate evidence is provided.